Hello everyone, welcome to Court with Krissy. I've got a fun pro se DUI jury trial with Judge Johnson. I've broken it down to 3 parts. This is just the beginning. It's good, and I hope you like it. Court with Krissy is now in session.
Everyone may be seated. So, good morning, everyone. Hi. Well, we're just going to wait just a couple of seconds because we did give both parties an opportunity to take a quick restroom break just before you came in. So the prosecutor just came in and we're waiting for the defendant to come back. All right. So again, ladies and gentlemen, good morning. And I'm Chief Judge Sheila Johnson, and it's my pleasure to welcome each one of you to the 46th District Court of the state of Michigan. So I know that jury service today might be a new experience for some of you. And jury duty is really one of the most serious duties that members of our free society are asked to perform. So our system of self-government really would not exist without it. So the jury is a very important part of this court. So the right to a jury trial is a very ancient tradition and part of our heritage as a country. So the law says that both a person who is accused of a crime and the prosecution have a right to have a trial by not one, but in this case, by a jury of 6 persons who will give them an impartial trial. Jurors must be as free as humanly possible from any biases or prejudices or sympathy for one side or the other. So each side in a trial is entitled to have jurors who keep open minds until the time comes to decide the case. So a jury trial begins with jury selection. And so the purpose of this process is to obtain information about you that will help us choose that fair and impartial jury for this particular case. During the selection process, the lawyers and I may ask you questions. This is called voir dire. And the questions are meant to find out if you know anything about the case. Also, we need to find out if you have any opinions or personal experiences that might influence you for or against the prosecution, the defendant, or any particular witness. One or more of those things could cause you to be excused in this particular case, even though you may otherwise be qualified to serve as a juror. So the questions may probe deeply into your attitudes and your beliefs and your experiences. Now, they are not meant to be an unreasonable prying into your private life, but the law does require that we get this information so that we can pick that impartial jury. So if you do not hear or understand a question, then you should say so. If you do understand it, then you should answer it truthfully and completely. Please do not hesitate to speak freely about anything that you believe that we should know. So during the selection process, you may be excused from serving on the jury in one or two ways. First, I may excuse you for what we call cause. And that is, I may decide that there is a valid reason why you cannot or should not serve in this case. Or a lawyer from one side or the other may excuse you without giving any reason for doing so. This is called a peremptory challenge, and the law gives each side the right to excuse a certain number of jurors in this way. So if you're excused, you should not feel bad or take it personally. As I explained before, that there simply may be something that causes you to be excused from this particular case. So I'm going to ask each one of you to stand and raise your right hand to take your oath to answer truthfully, fully, and honestly all of the questions that you will be asked about your qualifications to serve as a juror in this case. Now, if you have some religious beliefs against taking an oath, you may affirm that you will answer all the questions truthfully, fully, and honestly. So, please stand, raise your right hand. Here is your oath.
Do you solemnly swear or affirm that you will answer truthfully and completely all questions about your qualification to serve as jurors in this case?
Yeah. Thank you. Have a seat. So, because we are going to be probing a little deeply into your knowledge, your beliefs, your attitudes, this is only fair that we introduce ourselves to you a little bit more fully so you can get to know us. So again, I am Judge Sheila Johnson. I'm the Chief Judge of this court, and I will be presiding over this particular trial, keeping everything in order. And you have met one of my staff members who was my court officer, who was Court Officer McClanahan, Charles McClanahan. His job generally is to obviously keep everything all safe, to keep some decorum here, keep everybody in place. And for this trial, he will be keeping you in some safe place until you have finished deliberating and you're released. So he will be basically your contact person to me as to whatever your issue may be. He will be writing a note to him and he will be transferring information to me. Over to, well, let's take a look at this empty seat right here. You're used to seeing that person typing and, taking the transcript down. Well, unfortunately, those jobs are not here in this court anymore. Technology is kind of taken over. So what we have now is a camera system and a video system. So if you notice, you see all up here on the screen, there's tons of camera angles of me and you and everything else. So we have cameras here and cameras here and cameras over there. And so there's a video system attached to it. And so we record every single thing that's going on here. And so, as you know, it's difficult to hear when people talk over each other. So that's why it's very important for the parties and anybody else not to speak when someone else is speaking, so that if we needed to order a transcript, we would have a clear transcript. So what we do now is we can't read anything back to you because there's nobody to do that. So if we needed a transcript, though, then that's when a court reporter would come into play, and they're certified to transcribe from our audio and video tapes. Okay, so we do have one other person over here, and stand up over there so we can see you. That's Miss Jessica Liddell. She is my assistant. Say hello, Jessica. And she is a very important part of my life here in this courtroom and outside really too, because she is my assistant. So she's the first point of contact if you had any business in my particular chambers. So she's going to be answering the phone. She's going to be answering your questions. She's going to look up information on your cases. Her job is also to keep those cases moving. So the hundreds of cases that we have pending, she's in charge of making sure their schedule, something is going on any of them, especially civil cases, which they may be deadlocked a little bit. So she's checking to make sure it's on a quick track to get resolved. And also today, she's got a little job of tracking what's going on here in the court today. So that's really my staff. And so that's what each of the judges has. It's a court officer, no court reporter, and a judicial assistant. So as you may have heard, just by the language I was using about prosecution and defense, that this is a criminal case involving a charge of operating while intoxicated. So I'm going to explain that charge to you a little bit more fully later. This charge has been made against the defendant, who is Mr. Thomas Aaron Johnson. Now, Mr. Johnson is representing himself today. So, Mr. Johnson, please stand. Face the jurors and introduce yourself and any person. You don't have a person with you at council table, okay? And so the other lawyer is the lawyer for the state of Michigan. Representing the people of the state of Michigan is our assistant prosecuting attorney, Miss Michelle Mitch. So Miss Mitch, would you please stand and introduce anyone? You don't have anyone at council table either.
Hi, everyone. Good morning. My name is Michelle Mitch. I am an assistant prosecuting attorney with Oakland County. My job today essentially is to talk all day. So I apologize front that you have to listen to me all day if you are selected in those 6 seats, but thank you for me.
Okay, Miss Mitch, do you have a list of possible witnesses that you may be calling?
I do, Your Honor. The people today plan to call Trooper Hinson with the Michigan State Police. We plan to call Paul Ham. He is an RN at McLaren Hospital. And we also plan to call Mr. Ryan Gifford. He is a forensic scientist with the Michigan State Forensic Lab. Does anyone those names sound familiar to anybody? No?
All right,
Thank you.
because if you do know any of those persons, or if it dawns on you later that you think you know them, then please let us know. Especially if you're selected here to be seated in one of those 7 chairs, okay? But for right now, no one knows any of those persons, correct? Okay. All right. So we think that this trial is going to last for approximately today. Worst case scenario, if it got long, or I'm hoping it doesn't get long, that, you were deliberating, you might have to come back tomorrow morning, but we're hoping to finish this today. So if you believe that the length of the trial will be a hardship for you, then please let us know. Okay. Now, some of you may have health problems that would prevent you from serving on a jury. For example, if you have a medical problem that makes you unable to sit for 2 or 3 hours at a time, then let me know that, because we will try to accommodate that. We would take more frequent breaks to allow you to do that. If you need to eat because you're diabetic, then we would take breaks for that, for you to get a snack or whatever you need to do in order to accommodate that. If you're someone who needs more frequent restroom breaks, please let us know that, and we can certainly break for that as well. If you have a sight or hearing problem, please let us know. We can try to accommodate that, but we need to know whether or not you do have that problem as well. And if you have a language barrier, that English is not your first language and you have some problem understanding some things, please let us know that as well when you're selected. So keep that in mind, because if you're seated in those seats and I ask you, is there anything you want to let us know, please let us know those things. Okay. Let's do this. Let's have everybody be seated first. And I'm going to call you up in order. Now, when I say order, this is nothing that I put together. I never know until I get your information from the jury clerk exactly who you are and what order that you've been listed in. So this is all computerized as it comes to us from the county. Okay, so I'm going to call you up in the order, and you're going to be seated in these seats. Number 1 is over there closest to you. Number 7 is over here furthest away from you. So let's call you up and have you be seated in those seats, and then we'll get started with the process. All right. So in seat number 1, juror number 1, Mr. Isaac Lewis. All right. And seat number 2, juror number 2, Miss Amber Mandler. And seat number 3, juror number 3, Mr. Carlos Garcia Perez. And seat number 4, Miss Miranda French. And in seat number 5, juror number 5, Miss Amelia Winchester. And seat number 6, juror number 6, Mr. Frank Lapierre. And seat number 7, juror number 7, Mr. Justin Roberts. So, as we go through the process, some may be excused, and we'll go through that in just a moment. But if they are, then they'll step back down into the audience, and we're going to call the next person in line to come back up. And we're going to try to start with the same types of questions. So if you're not seated there now, just keep your mind set on the questions that we're asking, because those are the ones that we're going to ask you. And if something pops up that you think you want to offer to us, then you'll be ready. Okay? So this is a criminal case, and the paper used to charge the defendant with a crime is called a complaint. Now, the information and a complaint in this case charges the defendant, and that's Mr. Thomas Johnson, with the crime of operating while intoxicated. And it would read as follows. Let me get it. That in the city of Southfield on December 20th, 2023, the defendant, contrary to law, did operate a vehicle upon a highway, 8-mile road, under the influence of alcoholic liquor and or having an alcohol content of 0.08 grams or more per 100 milliliters of blood. All right, and so the defendant has pled not guilty to this particular charge. You should clearly understand that the complaint that I just read is not evidence. That a complaint is read in every criminal trial so that the defendant and the jurors can hear the charge. You must not think it is evidence of his guilt or that he must be guilty because he has been charged. Now, a person accused of a crime is presumed to be innocent. And this means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. So every crime is made up of parts called elements. The prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or the lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. So a reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. So those were just some preliminary instructions for now. And we'll start asking you about these concepts and other things about the case. But before we do that, we're going to ask each one of you just to loosen up the tenseness in the air. Tell us a little bit about yourselves and about your family, about if you're married, your spouse, where you work, where they work, do you have children, what they're doing. That's fabulous. Do you have any hobbies? Things of that nature. So let's start first with juror in seat number 1, Mr. Isaac Lewis. Good morning. Hi, good morning. You can if you want.
Work at Morgan Casino. I'm a cook. I have 6 kids, 4 girls, 2 boys.
What are their ages? What are your children's ages? Ages.
Oh
boy, this is a test for you, isn't it? Sorry.
Terrell is 31. Marquise is 29. Diana is 24. Isaiah is 22. They like 2 years apart. Aubrey is 16. That's my youngest.
Oh, wonderful. So most of them are out the house.
Yeah, all of them.
Good.
Except for 16.
But you want to tell us about you work in Motor City.
Yeah.
Are you married?
I am.
Okay. Do you have a spouse or a girlfriend or something? What does that person do? Your significant other?
She works there. She works Casino.
Let's see. Hobbies. What do you like to do?
Video games. I play ball.
All right. Sounds like fun though. Thank you so much for coming. Nice to meet you.
Yep.
Okay, seat number 2, Miss Amber Mandler. Hi, good morning.
Hi, I'm Amber. I am a behavior analyst. I work with kids with autism. My husband's an engineer. He works in environmental engineering. I don't.
All right. So let's talk a little bit about your work with autism. That is fabulous. What specifically?
So I oversee a large team of behavior analysts. Kids we provide applied behavior services in the line of ABA. Don't know what that is. We just sort of slow the whole teaching process down so that we can educate unique learners with unique needs, and sort of break things down. Sometimes you want to increase behavior, sometimes you want to decrease it by what's happening, and get direction with behavior.
So is there a specific age group that you're working with? Just go to adults?
Yeah, I mean, insurance covers up until ages, Medicaid currently only covers till like 21. Private insurance recently upped it, so technically we could provide services to adults as well, but that's still in the process of. Right now, I work for our company does like 2 or 3 to 21.
That sounds wonderful. It sounds like you're busy. What do you have hobbies and things you like to do?
I was just thinking, I work a lot, so I don't have a ton of hobbies, but I love to travel. I lived overseas for over a decade.
Oh, what country?
Middle East, so I was doing the autism thing in Kuwait and Qatar and the UAE and just helping to provide quality services to that part of the world.
Oh, wonderful. So you're kind of like an international resident in a sense. So, well, thank you for being here in the city of Southfield with us today. All right, thank you. And Mr. Perez, Mr. Carlos Garcia. Tell us a little bit about yourself and family.
I'm married, 7 years. Children, 3 and 21. My wife and I have she got it 4 years ago. Here in we are trying to fight for ourselves.
Oh, yeah. Well, it's getting a little bit better right now. So, yeah.
Man,
From where?
well, that's what they say.
Oh, yes. Yeah. Totally different than Texas. It's beautiful, and we do have a lot of seasons. And if you had been here maybe 10, 15 years ago, it was a lot of snow. It's not so bad anymore. I don't know if that's climate change or not, but welcome to the area. What do you do for a living?
I'm an engineer. Street.
Mhm. So are you like a design engineer or what kind?
Validation engineer. I'm working for electronic component vehicles that those comply with their requirement. Approve or disapprove the releasing action and use of vehicles.
All right, that sounds interesting. That is there one specific component that we would all be familiar with?
Oh, well, sure. Nowadays vehicles have cameras and radars looking forward
Mhm.
to detect vehicles in front of you.
Right.
To assist in case, if the option is loaded, it's braking for you, you trying to avoid accidents or something that goes over top clear and burn.
Mhm. So you're responsible for all of that technology and making sure that it's right. That's great. What's your wife do for a living? Your wife, what does she do?
She's an industrial engineer. She's working as a buyer for one company that's supply based, also for some of the
Wonderful. And you said you had two children, right? And they were like in, did you say in their 20s?
Yes.
Okay, good. They're out of the house. What did they do?
The oldest, she's at the Oakland Community College.
Mhm.
She's in graphic designing, studying that. Youngest is at the U of M, studying computing data science.
Oh, wonderful. I'm gonna have to give a plug. Go blue. But I don't want to offend anybody that's green out there either. Thank you so much for being here. And we appreciate your presence today. Seat number 4, Miss Miranda French. Hi, good morning.
Good morning. I'm Miranda. I'm 24 years old. I currently work as a medical assistant at a dermatology office. I graduated from U of M in 22 and I studied I studied biopsychology there. I'm going to be starting a case.
Oh, wonderful. Good. Not married.
No, I have a boyfriend.
Okay. What does he do?
He's in medical school right now.
Okay, good. Wonderful. You sound like a great team. Any hobbies?
I like to go for walks. I like to eat. I like to watch TV shows.
Good. Nothing on a computer, huh?
No.
No games, nothing like that. Okay, great. Nice to see you. And thank you for being here today. Seat number 5, Miss Amelia Winchester. Did I pronounce it right, Miss Winchester? Thank you.
Hi, my name's Amelia Winchester. I'm 21 years old. I am currently unable to work for college, so I'm a self-taught artist.
Oh, you're an artist. What do you do? What's your medium that you work in?
Mainly traditional and digital.
So we're talking photos, print, that kind of thing?
No, like I make my own art on digital art.
Digital art. Okay, wonderful. All right. Any other hobbies that you like to do other than that?
Play games, read books.
Yeah, good. Well, thank you so much for being here. I appreciate it. Nice to meet you as well. And seat number 6, Mr. Frank Lapierre. Good morning.
Frank here, years. Basically, just making songs sound.
So like if I'm a rapper and I want to come in there
Yeah,
and I want to, record something.
please do. Paying guys.
A shameless plug, right?
Makes sense.
All right. Mix Factory 1. That's interesting.
I don't got any hobbies.
Yeah, that takes up a lot of time for you, I'm sure. All right. No, not married, no kids. Okay, great. Thank you. And seat number 7, Mr. Justin Roberts. Good morning.
Justin Roberts, 40 years old, I'm married with 2 kids. 4.
Oh, wow.
Travels with snowboard, stuff like that. I work in inland water pollution control. Actually, it's pipe rehabilitation throughout Detroit, actually, state of Michigan.
Oh, wow.
I think break up this water.
Oh, wow. That's really interesting. I mean, so what's the state of the water around here?
They're mostly on the sewer and sanitary sides.
Yes.
Okay.
When you hear stories about, heavy rains and the flooding and sewage and things like that, you know, just makes you wonder about infrastructure and what can we do? So do you work in any of that aspect of it or not?
Oh, yeah, I'm currently working in a few larger projects out there. One of them being Gordon Hill Bridge.
Yeah, Gordon Howe, that new one, yeah.
Yeah.
Uh-huh, wow.
You know.
Is that open? Not yet. Okay, you look like it might not be for a while.
It's supposed to be open on Thanksgiving the 24th, so we'll see.
Okay, wonderful. We'll see. Well, what about your wife? What does she do?
She was a preschool teacher. We're actually only been here, I've been here 2.5 years in San Francisco.
Oh,
We came back, she's a stay-at-home mom for now.
okay. Yeah, well, those youngsters here, so that's good. Well, welcome back to Michigan. All right, so everyone, we're going to start just by asking a few questions. Now we've gotten to know everyone. As you heard, that this is a criminal charge, and the charge is operating while intoxicated. So, I guess I'm going to start by asking. Well, let me ask this first. Do y'all still live within the jurisdiction of this court, which would be Southfield, Lathrop Village, Franklin, Beverly Hills, Bingham Farms, Southfield Township? Anybody doesn't live there?
I didn't like where, but my still something.
Okay, but you don't actually live here. All right, because you have to live within the jurisdiction in order to serve. So we're going to ask you to step out and thank you. And yeah, get that address changed as soon as you can. And so that's in seat number 4, Miss Miranda French. So who are we going to call up to replace her? And that's juror number 8 and seat number 4, Miss Sarah DeWart. Okay, good morning.
Good morning.
Now, my first question is, do you still live within the jurisdiction? Okay. Tell us a little bit about yourself and your family.
Married. I have a little daughter and and swim.
Oh, wonderful. Are you married?
Yes.
Oh, what's your husband do?
Insurance.
Oh, wonderful. And so you said you got 2 little ones, so I bet they're keeping you busy.
Don't ever sit down.
Well, we're going to ask you to have a seat here today, and that'll be your rest while you're away from them. So thank you so much for being here. The next question we're going to ask everyone is, have you ever served as a juror before in any type of case? Anybody here? Oh, you have? Tell us a little bit about that, Mr. Ward.
It was a long time.
Child abuse, it was criminal. Was it in this court? It's Pontiac, so it was at circuit court. And without telling us your verdict, could you tell us whether or not you were able to reach a verdict? Okay. Is there anything about your jury service in that case that would make you feel that you couldn't serve as a fair and impartial juror in this particular case? Okay, good. All right. So as we were saying, this is a drunk driving or operating while intoxicated case. So has anybody ever, well, let's start with this. Got any drinkers? Yeah, I know. I'm not saying that you drink to an extreme, but just do you drink? Anybody drink? Raise your hand. Okay, good. So, do you believe that, do you have any issue with the fact that there's a law that says that after a certain level, you should not be driving, or if you cannot handle your vehicle in a proper manner, that you shouldn't be driving? So, do you have any problem with that, Mr. Lewis? All right, you.
Drink.
Okay. And what about you? How do you feel about that, Ms. Bandler?
Fine.
Okay, you're fine with that. And Mr. Perez? Okay. Anybody else have any problem with the fact that we do have a law on the books that says, well, after a certain point of intoxication, maybe, you shouldn't be driving, and that you have any problem deciding this kind of case? Anybody have a problem with that? Anybody have ever been stopped for drunk driving yourself? Okay, that's fair. Okay, Miss Amanda, tell us a little bit about that.
I had a DUI 25 years.
Okay,
It's been,
okay.
but I
19. And so one time for situation, do you believe that you were handled fairly in the system, so to speak? Would you have any problem sitting and being fair to both the prosecution and the defendant in this case and listening and making a judgment? All right. And so you don't have any thoughts or ideas like, police are horrible. They should never be stopping people like this. You don't have any feeling that, gosh, it happened to me and anybody who's accused of drunk driving is a horrible person. You don't have any feeling and biases like that.
No, honestly, I was young and it was a mistake, and I was grateful to the courts for funding reasons.
Okay, wonderful. And I saw, did you have your hand up, Ms. Looking? Oh, you did, Mr. Roberts, okay. Tell us a little bit about your situation.
I was 19, I got pulled over, got me coached minor presumption. Then about 6 years later, while drinking, I did get pulled over, I did get a DUI. Was convicted of that. Then I went about drinking. I've been in recovery for about 3-4 years now.
Okay, wonderful. And so how do you feel about sitting as a juror in that same type of a case that you were convicted of? You think you could do it fairly and open-mindedly? Do you feel like you were treated fairly in your situation?
By the cops,
Both.
by the cops, no, I lived in a pretty rough place, so I got beat up by the cops. But I was guilty.
Okay. And so you could keep an open mind and listen to whatever the evidence is and be fair to both the prosecution and the defendant in reaching your verdict. Wonderful. Anybody else have any relatives or friends that might have had a drunk driving or drinking and driving situation? Okay. And so that is Miss Winchester. Tell us a little bit about that.
When I was a kid, but my aunt always had problems, alcohol in and out of jail. My dad got stopped. He wasn't, but my aunt.
Yeah. And how does that affect you looking back at, the issue that you had with drinking and driving? Do you have some strong convictions against that?
She's had a rough life in a pretty rough place, so I knew that anything she didn't come from a bad place. But
So when you hear someone accused of that kind of thing, drinking, driving, and being, over limits or unable to handle their vehicle, do you think you could keep an open mind and listen to it without being affected by, the thoughts of what you saw in childhood? Okay, good. All right. Anybody here a member of any advocacy groups such as Mothers Against Drunk Driving? Donated to? Anything like that? Okay. Oh, yeah, go ahead. And that's Miss Dewar.
Yes, my brother-in-law was hit by a drunk driver against a wall.
Oh,
Was he has metal in his leg, and it's been about 5 years.
so he survived it, but he's a little handicapped by that.
Yeah.
Yeah, not quite the same. And so when you saw him going through that, how did you feel about the fact that somebody had been consuming alcohol and ended up doing this to him?
So
I can understand. So do you feel that anyone that might be accused of that, just you could keep an open mind? You're going to try to do that? All right. Because each person is different in each factual situation. Would you agree? You think it's different? And so we don't know anything about anything yet. So you could keep an open mind. And let's talk about that. Based upon what you've all heard so far, if I asked you right now what your verdict would be, what would your verdict be, Miss Mandler?
I am a behavior analyst, so I'm not sure if I have enough.
So what would your verdict be?
All I know is that the chart.
Verdict, please.
I can be.
Verdict. What's your verdict?
Based on the chart.
Based upon what you know, what you've heard as evidence, what would your verdict be? Okay, help her out, Mr. Roberts. So what would your verdict be? Anybody disagree with him? What would your verdict be, Mr. Lapierre? Miss Winchester? Okay, what about that, Mr. Ward? Mr. Perez?
Woman, I do not have a reference of what would be the allegedly.
So since you don't know it and you haven't heard any evidence, what's your verdict? Now, Miss Manley, what do you think?
Not guilty.
Okay, Mr. Lewis. Okay. I'm telling you right now, this gentleman here seated here, you have heard nothing. Do you think he's guilty because he's seated here? You think he must have done the crime because he's seated here charged? What do you think about that, Mr. Rob? Mr. Lapierre? What about that, Mr. Lewis? Is he guilty because he's sitting there charged? Is he guilty in your mind? Do you think he must have done it because they charged him, Mr. Manley? No? I can hear you.
No.
Okay, I can see your head shaking. What do you think about that, Mr. Warren? And Mr. Perez? Okay. Because the person who has the burden of proving this case is the prosecution. I read you that instruction that said presumption of innocence, that the person is presumed innocent until the prosecutor proves each element of the crime beyond a reasonable doubt. So, if you heard the evidence and you're thinking about what the court's going to tell you the elements are, and you thought, yeah, court told me, let's just say, for example, there's 4 elements that she has to prove. I got number 1, number 2, I got number 4. I'm not sure about number 3, and she didn't convince me on number 3. But your gut instinct is saying, but I bet he did it. What would your verdict be, Miss Manley? Right, you're real good now. Mr. Lewis, what would your verdict be? Anybody feel any differently? Shaking your head, no, Mr. Ward, you agree with that? Because the prosecutor has to prove each element beyond a reasonable doubt. It's a heavy burden. Does anybody have a problem with her carrying that burden? It's heavy. Other than her, anybody else have an issue? It's heavy. And your job is to see if she's carried it well. So I like to think of the presumption of innocence as being this cloak, this robe I got on. I call it the cloak of innocence. I should copyright that. But it is like this cloak. So as you go out through this whole trial, this gentleman here is considered not guilty no matter what you hear. You can keep it in your mind, but you don't make that determination until you get to the bench. You start talking. Anybody think they could keep an open mind like that? Keep a note of what you hear. Keep it open till you hear it all. Can you do that? So this is the cloak of innocence, right? Her job is to take it off. So you hear all of the evidence and you say to yourself, this is what she did. What does your verdict have to be? Anybody? Does anybody disagree? Because the cloak of innocence is still there. That means she did not prove every element of the charge to your satisfaction beyond a reasonable doubt. She might get it down some more. What if she has this arm on? Verdict? Good. She got to get this arm out. She got to get it all the way unzipped. She got to get the other arm out. It's got to drop to the ground. And you got to be convinced of that beyond a reasonable doubt. Even if you look at him and you say, I don't like him. You don't have to like him, but he still has a presumption of innocence. He could get on your nerves. Would you still be able to find him not guilty, ladies and gentlemen, if she didn't get this cloak of innocence all the way up? What do you say, Mr. Lewis? Could you do that? Could you do that, Miss Manley? Could you find him not guilty, Mr. Perez? What about you, Mr. Ward? Miss Winchester? Mr. Lapeer? Miss Rob? Let's say you like him. He presents well. He seems like a nice guy. And she hits every element on the money as far as you're concerned. Would you be able to convict him and give a verdict for the prosecution of guilty if she's taking this robe off? Could you do that, Mr. Lewis? Miss Manley? Mr. Perez? The work. Miss Winchester? Mr. Lapeer? Mr. Robin? Now, you're going to hear from some police witnesses today, potentially. Anybody have any bad experience with the police? Let's hear about it, Mr. Robinson. We'll come to you. Go ahead, Mr. Robinson. What was the situation?
There's been a few of them
Yeah, that's fair.
that got arrested when I was 17. Started my passion show. Oh,
It all went away.
that's him. Court. I don't have to be a lawyer, but I should give him a charge.
So how do you feel about police witnesses then?
No, I don't know about trade at the time. They didn't really come any testify.
Okay.
They ended up having to report without loaded charges.
Okay.
And again, when I was 20 something, so we could go back so where there weren't cameras. But, so,
Well, do you think all police officers are likely to lie and trump charges up on somebody? Do you think that there could be some that, we could easily rely on to do their job and to tell the truth? So would you be able to judge a police officer just like you would anybody else that you heard from and decide if you believe they're telling the truth or not?
Right.
So you wouldn't discard their testimony simply because they're the police? Okay, you keep a little bit of an open mind. And what would you do and how would you decide whether you thought you believed them?
it's litmus test, right? How would you know?
Well,
The person they present like that.
Well, you might look at it in terms of, does what they say make sense? How does it fit with all the other evidence that you might have heard? Those are the things that we're going to tell you to use in order to make that determination. Let's hear about your situation, Miss Winchester. You said it was kind of bad.
Also had a,
Few run-ins, yeah.
not like me personally, but like family.
Okay, tell us a little bit about it, how you think about police because of it.
Overall, we're all, everyone's capable. So I wouldn't judge it just because they're
Good. And by the same token, conversely, anybody judge a police officer and believe them because they're a police officer? Simply because they're the police. So They're sworn to uphold the law, protect, serve. If he or she says it, it must be the truth. Would you believe that, Mr. Lewis? So you would never think that they might lie or be mistaken as to what they saw. But do you know anybody that has never lied or been mistaken?
Right.
Do you know anyone who has never lied or been mistaken? So why would you think the police would be any different? They're human.
They just want to say. So, I mean, I never had any problems like that.
So you would simply believe them just because they said it. What about you?
They have to make them.
Mr. Perez, how do you feel about a police witness? Would you judge them any differently because they're police?
Somehow, yes.
Somehow, how?
Their job is exposing them to many situations, and their history might be different. So probably knowing a little bit of the background of the person can help us understand how their service life speak
Okay.
and understanding them how are thinking themselves.
Very good.
And, yeah, starting.
All right. So if they told you something, you think they would be more helpful to you because of their training and experience that you might really believe what they're saying is accurate.
So if they have more exposure to certain situations.
Okay, well, what if I told you the facts came out that the police officer didn't have a clear view of it? And somebody else was standing right there and said something different. Would you believe the police because he was there and more trained? Or would you take into consideration that he couldn't see it well, and somebody else saw it better? How would you reconcile that?
Well, you guys explained a few moments ago, be clear about what is being told here and the evidence presented regardless of the person that is being accused. Use the same principle with the policeman sent and showed here. Exceptional probation service of but in principle I big what I
Okay, let's ask you. Mr. Work, how do you feel about police testimony?
I would decline to.
Okay.
It's an honorable profession to go into to serve and
So what if some other people said something different? You would still believe the police officer just because they're the police.
not hands down, just before I'm honest.
And what about you, Ms. Winchester? How would you assess the police officer's testimony?
It's not whether it makes sense in line with the evidence. I really take their testimony just like with any other.
That's exactly the rule. You should not believe a police officer simply because he or she is a police officer. The rule says that you have to judge police officers' testimony the same as you would any other witness. Any other witness. Why do you think that might be? Some people lie. I'm not saying police do, but they could. You've all heard news reports of somebody lying and then the body cam shows something totally different. Or people see and hear things differently. They're not lying. They just might have gotten a different view than someone else. So your job would be to assess that, not because they're the police, but does it make sense? Is it believable? How does it line up with other witnesses' testimony and things like that to make your decision as to do you believe any witness's testimony? Okay, anybody have a problem with that? Can you be open-minded, Mr. Lewis? I know you say you like the police, you believe anything they say. Could you then be more open-minded to say, let me look at the evidence and see if what they're saying makes sense as against what maybe some of the other evidence showed? Okay, maybe from some evidence of some other witness's testimony. And then compare them and see if it makes sense. Not simply because they're the police. Could you do it? Okay. What about you, Mr. Press? Could you do that? Okay. And of course, Mr. Ward, I know you say you're more inclined because of the police, but you would be able to say, well, wait a minute. Police officer said the sky is purple. And everybody else on this said, no, it was blue. You might say, well, let me weigh what everybody else says against what that officer says and see how much it makes sense. And then that's how you decide if you, okay, because that's the rule. Okay, let me see if there's anything else I want to cover before I open it up to the prosecutor and then the defendant. Let's see. Anybody have a problem with, let's just say you had a scenario, the person was just driving just fine. But the law tells you that they have a certain limit of alcohol in their system. Do you have a problem with finding them guilty? What about that? Let's start with Mr. Roberts.
Why did you get pulled over? This fun.
Could be any number of reasons. Could have had a bad tag. Plate could have come back to a suspended license. Could be any reason why it got stopped. But if the testimony came out, well, he was driving, fine. You can get stopped for a lot of different reasons. Would you have a problem with convicting somebody because their bodily alcohol level was too high under the law? What about that for you, Mr. Lapierre? How do you feel, Mr. Lewis? And Miss Mandel. Okay. All right. I'm going to open it up to the prosecution. I might think of a few more good questions later. Go ahead, Miss Mitch.
Hi, everyone. I think it's only fair. You guys have spilled everything, so I might as well give a picture of myself. So again, Michelle, I do work with the prosecutor's office when I'm an attorney. My husband is an engineer. I have no idea what he does. I'm just an architectural engineer. I let it work. And I walk away, but honestly, it makes my head hurt. So all your engineers, good for you. I do have a 2.5-year-old. He runs my life. He's very demanding. And number 2 is not coming soon enough. So we'll be there as well. But that's really our lives. So hobbies are work. That's all I do is work. And just make sure that my 2.5-year-old is not getting into things she shouldn't be getting into. So that's about all for now. I think what I wanted to start with, because honestly, I want to know more about Mr. Roberts' life. You're not going to tell me all of it. It's totally fine, but I wanted to hear all those stories of, not just stories, but what happened to you back when you were 17. My main question is, there was going to be an officer testifying today, a state trooper with Michigan State Police, and he's going to essentially testify as to what happened. And there may or may not be video that is shown as well. I just want to be sure that I understand your input. I would agree with you on having some apprehensions for the police with everything you've gone through and talked about today. Today's purpose is of hearing Trooper Hinson. Would you be inclined to not believe him because of your situation of what happened before? Oh, go ahead. Sorry.
Say he would have a part or hold you to a higher standard than just a regular witness. It's about safe profession and what they do.
But not because of what necessarily happened to you when you were younger. Okay. But that's fair. Like I said, I don't have a doubt that you have some apprehensions towards officers. I would too in your circumstance, and I don't understand that. I just wanted to make sure that we're all on the same kind of level, same playing field. I think a big thing that we didn't touch on yet was reasonable doubt. And that is what our burden here is today, is reasonable doubt. Does anyone want to guess as to what that means? Does anyone believe it's 100%? You have to be 100% convinced that this person is guilty. Do you believe it means maybe 99%? So I use my little puzzle analogy. Let's say I have a 10-piece puzzle, right? And let's say I have 8 of these pieces put together. And when you look at it, it's clearly Mickey Mouse, right? You know what Mickey Mouse looks like, right? Everyone kind of at this point probably knows. Let's say I'm missing the top corner piece over here that's in the sky, the picture. And let's say I'm missing part of Mickey's shoe, right? With those 2 pieces missing, can you still tell that it's Mickey Mouse? Does anyone need that sky picture and that shoe picture to determine that it's Mickey Mouse? Staring very intently at me, Mr. Roberts.
On the civil, it was 50/50, and I thought most of the cases was a percent sure, so.
Okay, no, that's fair. So judge will give you the jury instructions at the end of this trial, actually the beginning of it as well. And beyond a reasonable doubt is a doubt that still leaves you firmly convinced of the defendant's guilt. Judge Johnson had a really great analogy with her cloak of innocence, right? No, having the arm out, not enough. I agree with that. Having it halfway down, not enough. I agree with that. Let's say it's hanging from a thread at the bottom. Does anyone agree that's reasonable doubt? Anyone disagree with that? Does anyone need 100% certainty? Let me say this. Mr. Roberts, for 100% certainty, why would we be here today? Right? Correct. Do you believe that anyone has 100% knowledge of what happened besides maybe the person who's alleged to have committed the crime? So, in the eyes of, I guess, the law, or what I perceive it to be, and again, judge will give you the exact instruction. Reasonable doubt, again, it's a doubt that leaves, or it's a fair and honest doubt. It's a firmly convinced that this person committed what they're alleged to have committed. If you don't have that, obviously, I know we already talked about it. You're perfectly not guilty, right? If you were 100% sure of what happened, if you were 100% sure of what happened, you'd be on that stand testifying as to what happened, right? Because you were there, saw it, you know what happened. So if I'm missing that side piece up there, again, will anyone have an issue with still seeing the facts of the case and having that? There could be that reasonable doubt. That reasonable doubt is what makes him not guilty, right? But beyond that reasonable doubt, without that sky picture, does anyone disagree that you can find him guilty versus not guilty? It's okay to say no. If you did 100%, Mr. Roberts, I get it. I'm not judging.
Some jury system was designed, we'd rather let her guilty man go than lock up on 3 months.
That's fair. That is fair. All right. Really, that's all I have, Judge. You've kind of covered most everything. I don't want to keep talking because again, you're gonna talk all day. So.
All right, thank you, Ms. Mitch. And Mr. Johnson, now you have an opportunity to ask any questions of the jurors about their qualifications to serve as jurors and their opinions on things. So go ahead.
Hello, everybody. Really, you know what I'm saying? That because really can't talk to me.
You can walk that way.
Everyone here has children. What about if you was pulled over and the reason why you was pulled over, you didn't get the ticket? I say you got pulled over, you didn't get the ticket for it. How would you feel about that?
Do you understand the question?
Yeah, and say you get pulled over, right? You don't receive the ticket for the reason why you pulled over.
I've had it. Wow.
Yeah. Have you had that?
I'm not, I don't think I have had that.
They wrote your ticket when you got pulled over. They wrote your ticket when you, have you ever been pulled over?
I had been pulled over.
Did they write your ticket for what you was pulled over? You will drive? You know it? Yeah. You? Of course you have. You like me. So I'm saying you always got a, they always wrote you a ticket for when you were pulled over. You'll have to. I'll have.
All right, and No, you're done? All right. Any challenges for cause?
Nothing for cause, Your Honor, from the people.
All right. Any challenges for cause? Okay. Peremptory challenges for the people?
Your Honor, the people people are satisfied with the jury panel.
Any peremptory challenge for you? That means someone you would like to dismiss.
What's that, Sarah DeWalt? Just on the fact that,
Oh, no, you don't have to give us an explanation. Just, you can dismiss her for any reason. Mr. Well, come on, step down. You leave your pad there. Have a seat in the audience. And to replace Mr. Watt, we're going to call up juror number 9. That would be Miss Jessica with a Y, Walden. Yeah. Oh, for the defense. Oh, not cause. Birthday. I'm sorry. And good morning still. Tell us a little bit about yourself.
I am a business consultant with an insurance company.
Okay.
Have a boyfriend. I have no kids yet. 16-year-old. I call my mom mistake.
What did your boyfriend do?
He's an aerospace contractor.
Oh, okay. Wonderful. Well, you still live within the jurisdiction of our court? Ever been a juror before?
Yeah.
Did you have anything that popped out that you wanted to let us know?
No.
All right. So you can have a seat. Sure. So you heard some of the questions that you know that this is a trial about drunk driving. So if you had any experience with drunk driving or people you know, and how do you feel about it?
Overall, I feel about it. So when I was 20 in college, I did have an incident where I was and arrested. Very young, just irresponsible, and it was a mistake. Since then, I've had no incidents whatsoever. And I had to pay fines. It's pretty much the end of it.
So how do you feel about sitting and deciding a case like this that you were once involved in? Do you think you can keep an open mind? So you don't harbor any resentment against law enforcement for stopping you? You think you were treated fairly?
Yes.
Okay. And you heard a little bit about presumptions of innocence and burden of proof. Just went over that a little bit. And so you understand the fact that Mr. Johnson here, as he's seated there right now, is innocent. So if you're listening to the thought to yourself, oh, I sure wanted to know what he thought about something, but you don't hear it. What would you think? Would you hold it against him? Because he didn't say or do anything?
No, I don't hold it.
Why not?
I mean, overall, my determination was based upon all of the evidence.
So by her, not him. So he doesn't have to do anything, does he? Exactly. So everybody get that? He doesn't have to do anything. He could just sit there and watch. You can't draw a conclusion from that because she has the burden of proving. What about that, Mr. Perez? You have a problem with that?
Yeah, alert me plus some.
Good. All right. What about that, Miss Manlin? You don't have a problem with that? And Mr. Lou? No problem. Okay. All right. Okay. So you heard a little bit about the cloak of innocence. And her burden is a heavy one, but she gets the cloak off to your satisfaction beyond a reasonable doubt. Could you convict him? Even if you like him, looks like a good guy, you could convict him. And if she did prove her case, you thought, seems like to me, probably did it.
Yes. My
Exactly. Okay. Because you can't go by what you think. in the back of your mind what could possibly be. You got to go by what's on the record, right? The evidence. And you have to be persuaded by that. Anybody have a problem with that? Okay. Let's see. We asked a little bit about police witnesses. Have any bad or even good experience? Trying to make the police bad people. Do you have any good experiences with the police that would make you think they're wonderful and believe everything they say?
They've all been, I don't, I only had the one stuff, other than that.
So you heard the instruction really will be to judge their testimony like you would any. Make it make sense to you, not just simply because they're the police. So you don't have any problem with that? Okay. Let's see. Did I miss anything? Okay, I'm gonna open it up. Did you have any questions for Mr.?
No, I don't, Your Honor. Thank you.
Did you have any questions, Mr. Johnson? Okay. Do we have any, let's see, challenge for cause?
Nothing from the people, Your Honor.
For cause. And now peremptory for the prosecution?
Nothing from the people, Your Honor. Again, the people are satisfied with the jury count.
Okay. Any peremptory?
That's fine.
Okay, wonderful. Ladies and gentlemen, we do have a jury. So, let's see.
Can I only ask for a favor?
Yes, sir.
When the lawyer speaks, slowly for,
Sure.
speak very fast.
Oh,
Okay.
Absolutely. And thank you for saying that, because that's what we want you to do is speak up. If you don't hear clearly or you don't see something clearly, let us know. And we'll certainly make an accommodation for you. So Ms. Mitch will slow down just a little bit. All right. So can we ask each of you 7 to stand and raise your right hands to take an oath? Ready, Jessica? So members of the jury, you have been chosen to decide a criminal charge made by the state of Michigan against one of your fellow citizens. I'm now asking you to stand and swear to perform your duty to try this case justly and to reach a true verdict. If your religious beliefs do not permit you to take an oath, then you may instead affirm to try the case justly and reach a true verdict. Here's your oath.
Solemnly swear or affirm that in this action, now before the court, you will justly decide the questions submitted to you, that unless you are discharged by the court from further deliberation, you will render a true verdict, that you will render your verdict only on the evidence introduced and in accordance with the instructions of the court.
All right, thank you very much. You may be seated. The rest of you, it's been my honor and pleasure. I'm sorry I didn't get to meet each of you, more directly and to interact with you, but we appreciate your presence here today because, quite frankly, without you, the system doesn't work at all. And so even though you've sat here patiently for the last several hours, you have served your jury service to this court for the next 12 months, the next 12 calendar months. You might be, called again to serve, but it may be circuit court or probate court, or maybe even federal court downtown. You're wondering how we choose you? Well, it's really through the driver's license records, state IDs, and voter registrations. And you get that information and you're called. And some people say they've lived around the area forever, 50 years, never been called, first time. Some people say, I just moved here, been called 3 times in a row each year. So it's just the luck or unluck of the draw, so you say. We will be giving you a little token of our appreciation. You will get the proverbial check in the mail. It doesn't really reflect how we hold you in high esteem, but it is set by the legislature. And so you will be getting that as well as a juror certificate, which feel free to frame that and put that in your living room to remember us by. Other than that, if you need something for work, you will be able to check in downstairs at the jury clerk, and she would be able to give you something if the subpoena you got wasn't enough. So again, on behalf of myself and everyone at the court, thank you for being here. They may take you back to the jury room. You may be greeted by one or more of the other judges, but if not, then thank you so much, and we'll see you next time. All rise for the jurors, please. Can you call one and quarter? We're gonna take these. Charles is doing that.
I will confirm.
Oh, you'll be a chance to go get it. Hold on. All right, everyone may be seated. So, we're gonna have, I'm gonna read you a few instructions. Then we're going to take a break for lunch and come back, and a court officer will give you, a little tour to the back to show you where you're gonna check in and where you're gonna be deliberating back there. So I'm going to find it, read you an instruction just about, being cautious about who you're going to be talking to. Make sure that as you leave the building, keep your juror buttons on and visible, because you could run into somebody that's related to the case in the hallway and they're not supposed to be talking to you. All right, so you must not discuss this case with anyone, including your family or friends. You must not discuss it with other jurors until the time comes for you to decide the case. When it's time for you to decide this case, I will send you to the jury room for that purpose. Then you may discuss the case amongst yourselves, but only in the jury room and only when all of the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone else who may be connected to this case. This means you may not speak to these individuals, even if it has nothing to do with this case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. This restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop. Explain that you're a juror and you're not allowed to discuss the case. If they continue, then leave and report the incident to our court staff or the court officer as soon as you return to court. When this trial is over, these restrictions will no longer apply, and when it's over, then you may, if you wish, discuss the case with anyone. The restrictions that I'm about to describe are meant to ensure that the parties get a fair trial. In our judicial system, it's crucial that jurors are not influenced by anything or anyone outside the courtroom. So under the law, the evidence you consider must meet certain standards. For example, witnesses must be sworn to tell the truth, and the lawyers must be able to cross-examine them. And the lawyer means the defendant as well. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. So these restrictions start now and they continue until I discharge you from jury service. It is your duty as a juror to decide the case based solely on evidence that you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentaries about the case, whether in newspapers or television, radio, internet, or social media platforms. You must not research any aspect of the case during trial. This means research using your cellular phones, your computer, or other electronic device to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any type of experiments concerning this case, including investigation or experiments using internet, cell phones, computers, or other electronic devices. You must not visit the scene of any event at issue in trial. If it is necessary for you to visit or view the scene, then the court staff would take you there as a group under court supervision. You must not consider as evidence any personal knowledge that you have of the scene. You must not share any information about the case by any means, including cell phone or social media. This means that even if you're not discussing the case with someone else, You may not post any information about the case on social media websites or in any other manner. And if you discover that a jury has violated my instructions, they'll report it to the court staff. Okay. So basically, just, don't talk to anybody. Don't discuss it even with yourselves, amongst yourselves, until I tell you to do that. So if most of you are from around here, you know that there's plenty of great restaurants all up and down Evergreen, right across from this Civic Center complex. You feel free to go home if you think you can get back and come back by the appropriate time. We usually take an hour and a half for lunch, would be from 12 to 1:30. If you would like to take a shorter lunch for an hour, we could do that. So it's up to you. Let's have a show of hands. Anybody want to take a shorter lunch? 1, 2. Okay, that's the majority. That's about 5 of you. So let's come back at about 10 minutes after 1. And we'll have a court out. You can feel free to leave your notepads in the chair. And we'll come back at about 10 after 1. So Charles, you can take them out.
Okay, all rise for the jury.
Are you the alternators?
No. Anybody else have anything over there he should grab for you? No.
We need to carry that court letter.
No, you can take it with you. We don't need it right now, but take it with you. Okay, the record should reflect that each of our 7 jurors is outside of the presence of the court at this time. Anyone may be seated if you like. Just if there's any questions about anything right now, Mr. Johnson, you have anything, we're going to need your cell phone because you tend to get lost. So we're going to call you.
I ain't got my cell phone. Our phone.
Well, we'll call, quote, her phone. Okay, well, you need to give us.
313.
No, wait, just write it down. Yeah, you can write it down.
Thank you. I try not to get lost. I always make it every court day.
Venture. You do.
Thank you.
Okay, so we're gonna take a recess now, and we'll see everybody back at about 1:10. Hopefully, we'll get started before 1:30. All right, we're off the record. I believe, Jesse, you got the jabs.
Oh, yeah, let me with the Charles.
I was gonna see winding on.
He does everything the man said is not supposed to do.
What?
Go off. Call the last week.
You already joined the meeting?
Yeah. It's just I have to wait for the TV to pop on.
You started it? Let's see, we're back on the record with case numbers 24M00319 SD and M4312745 ASI. Both are people of the state of Michigan versus Thomas Johnson.
Michelle Mitch on behalf of the people.
Thomas Johnson.
All right, so we took our brief recess for lunch. In the interim, it has been somewhat eventful because you have one juror back there who apparently did not leave for lunch and apparently was laying on the floor when she was found by someone. So I'm not sure what she said. She felt ill, like she was going to throw up. I don't think she did throw up, but I don't know what you want to do. So we could bring her back, see how she's doing. We could agree to stipulate if you wanted to make her the alternate. What's her status? Does anybody know?
I just went and checked on her. She's down. I guess Shalonda separated her.
Mhm.
She's down in Judge Armand's jury room. But she's okay. She looks a little weak and lethargic. That she was okay.
Well, she says she's okay, then I guess we don't have an issue.
I would say that's fine, Your Honor.
Okay.
I would say maybe we just need to take more breaks than normal to make sure she's okay.
But I don't
If
think
needs
I
to.
don't think she ate, but I don't know if she wanted to eat, and I know she didn't leave the building.
I gave her crackers, so I ate those.
I don't want to tell her how she is or isn't feeling, so if she says she's feeling okay.
Right, all right. Well, if that's the case, I don't know if you want to do you want me to bring her in separately, see how feels about it? I mean, if she says she's fine and she's able to, proceed to pay attention and deliberate, then we'll just bring her in with the rest of them.
Ready?
I'm ready.
Excuse me, what, jury was that?
Seat number 5. Hey, Jess, could you do me a favor? Could you go grab me the copy of this?
Make your copy.
And put a punch in it once you can.
You're all rise for the jury.
Judge, you want to get the whole part?
Yes.
Your original.
All right, y'all may be seated. Okay. Everyone, if you want to be seated, you may. The record should reflect that each of our 7 jurors are present, seated in the courtroom in their respective seats. Trust you all had a good lunch break. And now we're ready to proceed. I will ask juror number and seat number 5, Ms. Winchester. Are you feeling okay? Right. Do you believe you're okay to listen? Tell us if you need a break. You need some water, crackers. We have something like that if you're not feeling well. Okay. All right. So, ladies and gentlemen, so I'm going to give you some preliminary instructions, and of course, you'll get some other instructions a little later as we get through this trial. No one can predict the course of a trial, so these instructions will likely change a bit towards the end of the trial, and at the close of the trial, I'll provide you with a copy of my final instructions for you to use during your deliberations. Now I will explain some of the legal principles that you will need to know and the procedure that we will follow in this trial. So the defendant is charged with operating while intoxicated. And to prove this charge, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, the defendant, is charged with operating while intoxicated and or with an unlawful bodily alcohol level and or while under the influence. So to prove this, the prosecutor must prove each of the following elements beyond a reasonable doubt. First, that the defendant operated a motor vehicle. To operate means to drive or have actual physical control of the vehicle. Second, that the defendant operated the vehicle on a highway or other place open to the public or generally accessible to motor vehicles, including any designated parking area. Third, that the defendant was intoxicated. That is, the defendant A, operated the vehicle with a bodily alcohol level of 0.08 grams or more per 100 milliliters of blood, or B, operated the vehicle while under the influence of alcohol. Under the influence of alcohol means that because of drinking alcohol, the defendant's ability to operate a motor vehicle in a normal manner was substantially lessened. To be under the influence, a person does not have to be falling down or hardly able to stand up. On the other hand, just because a person has drunk alcohol or smells of alcohol does not prove by itself that the person is under the influence of alcohol. The test is whether, because of drinking alcohol, the defendant's mental or physical condition was significantly affected and the defendant was no longer able to operate a vehicle in a normal manner. The prosecutor must also prove beyond a reasonable doubt that the crime occurred on or about December 20th, 2023 in the city of Southfield or within 1 mile of the city of Southfield. Any offense committed on the boundary line of 2 counties or within 1 mile of the dividing line between them may be alleged in the complaint to have been committed and may be prosecuted and punished in either county. Now, a person accused of a crime is presumed to be innocent. This means that you must start with the presumption that the defendant is innocent. This presumption continues throughout the trial and entitles the defendant to a verdict of not guilty unless you are satisfied beyond a reasonable doubt that he is guilty. Every crime is made up of parts called elements, and the prosecutor must prove each element of the crime beyond a reasonable doubt. The defendant is not required to prove his innocence or to do anything. If you find that the prosecutor has not proven every element beyond a reasonable doubt, then you must find the defendant not guilty. Proof beyond a reasonable doubt is proof that leaves you firmly convinced of the defendant's guilt. A reasonable doubt is a fair, honest doubt growing out of the evidence or lack of evidence. It is not merely an imaginary or possible doubt, but a doubt based on reason and common sense. A reasonable doubt is just that, a doubt that is reasonable after a careful and considered examination of the facts and circumstances of the case. Now, a trial follows this procedure. First, the prosecutor makes an opening statement where she gives her theories of the case. The defendant's lawyer, or the defendant in this case, does not have to make an opening statement, but he may make an opening statement after the prosecutor makes hers, or he may wait until later. These statements are not evidence. They are only meant to help you understand how each side views the case. Next, the prosecutor presents her evidence. The prosecutor may call witnesses to testify and may show you exhibits like documents or objects. The defendant has the right to cross-examine the prosecutor's witnesses. After the prosecutor has presented all of her evidence, then the defendant may also offer evidence, but does not have to. By law, the defendant does not have to prove his innocence or produce any evidence. If the defense does call any witnesses, the prosecutor has the right to cross-examine them. The prosecutor may also call witnesses to contradict the testimony of the defense witnesses. And after all the evidence has been presented, the prosecutor and the defendants will make their closing arguments. Like the opening statements, these are not evidence. They're only meant to help you understand the evidence and the way that each side sees the case. You must base your verdict only on evidence. Now, my responsibilities as the judge in this case are to make sure that the trial is run fairly and efficiently, to make decisions about evidence, and to instruct you about the law that applies to this case. You must take the law as I give it to you. Nothing that I say is meant to reflect my own opinions about the facts of the case. As jurors, you are the ones who will decide the case. Your responsibility as jurors is to decide what the facts of the case are. This is your job and no one else's. You must think about all the evidence and all the testimony and then decide which piece of evidence, what they mean, and how important that you think it is. This includes how much you believe what each of the witnesses said. What you decide about any fact in this case is final. Part of your job in deciding what the facts of the case are is to decide which witnesses that you believe and how important you think their testimony is. You do not have to accept or reject everything that a witness says. You're free to believe all, none, or a part of a person's testimony. In deciding which testimony you believe, you should rely on your own common sense and everyday experience. However, in deciding whether you believe a person's testimony, you must set aside any biases, prejudices that you may have based upon the witness's race or national origin or ethnicity, gender identity, or sexual orientation, or religion, age, or socioeconomic status. There is no fixed set of rules for judging whether you believe a witness, but it may help you to think about these questions. Was the witness able to see and hear clearly? How long was the witness watching or listening? Was anything else going on that might have distracted the witness? Does the witness seem to have a good memory? How does the witness look and act while testifying? Does the witness seem to be making an honest effort to tell the truth? Or does the witness seem to evade the questions or argue with the lawyer or the defendant? Does the witness's age or maturity affect how you judge his or her testimony? Does the witness have any bias or prejudice or any personal interest in how the case is decided? Have there been any promises, threats, suggestions, or other influences that affect how the witness testifies? In general, does the witness have any special reason to tell the truth or any special reason to lie? All in all, how reasonable does the witness's testimony seem when you think about all of the other evidence in the case? When it is time for you to decide the case, you're only allowed to consider evidence that was admitted in the case. Evidence includes only sworn testimony of witnesses, the exhibits that are admitted into evidence, and anything else that I may tell you to consider as evidence. The questions that the lawyer or the defendant may ask the witnesses are not evidence. Only the answers are evidence. So you should not think that something is true just because one of the lawyer or the defendant asks questions that assume or suggest that it is true. I may ask some of the witnesses questions myself. These questions are not meant to reflect my opinion about the evidence. If I ask questions, my only reason would be to ask about things that may not have been fully explored. During the trial, you may think of an important question that would help you understand the facts of the case. you are allowed to ask such questions. You should wait to ask questions until after a witness has finished testifying and both sides have finished their questioning. If you still have an important question after this, do not ask it yourself. Raise your hand, write the question down, pass it to the court officer, who will then give it to me. Do not show your questions to other jurors. If your question is not asked, it is because I determined under the law that the question should not be asked. Do not speculate about why the question was not asked. In other words, you should draw no conclusions or inferences about the facts of the case, nor should you speculate about what the answer might have been. Also, in considering the evidence, you should not give greater weight to testimony merely because it was given in answer to questions submitted by members of the jury. If you cannot hear something that is said or presented, or if you cannot see a witness or evidence, please raise your hand immediately. During the trial, the lawyer or the defendant may object to certain questions or statements made by the other lawyer or defendant, or by a witness. I will rule on these objections according to the law. My rulings for or against one side or the other are not meant to reflect my opinions about the facts of the case. Sometimes the lawyer or the defendant and I will have discussions out of your hearing. Also, while you are in the jury room, I may have to take care of some other matters that have nothing to do with this case, so pay no attention to these interruptions. You must not discuss the case with anyone, including your family or friends. You must not discuss it with other jurors until the time comes for you to decide the case. When it is time for you to decide the case, I will send you to the jury room for that purpose. Then you should discuss the case among yourselves, but only in the jury room and only when all the jurors are there. You must not talk to the defendant, the lawyers, the witnesses, or anyone who may be connected to this case. This means that you may not speak to these individuals, even if it has nothing to do with the case. You should be very cautious about speaking to people because you may inadvertently speak to someone connected to this case. The restriction is necessary to avoid even the appearance of any improper conduct on any person's part. If anyone tries to discuss the case with you or in your presence, tell them to stop and explain that you are a juror and you're not allowed to discuss the case. And if they continue, leave and report the incident to the court officer as soon as you return to court. And when the trial is over, of course, the restrictions no longer apply. And when the trial is over, you may, if you wish, discuss the case with anyone. The restrictions that I'm about to describe are meant to ensure that the parties get a fair trial in our judicial system. It's crucial that jurors are not influenced by anything or anyone outside the courtroom. So under the law, the evidence you consider must meet certain standards. For example, witnesses must swear to tell the truth, and lawyers, or in this case, the defendant, must be able to cross-examine them. Because information obtained outside the courtroom does not have these safeguards, it could give you incorrect or misleading information that might unfairly favor one side. These restrictions, of course, start now and continue until I discharge you from jury service. It's your duty as a juror to decide the case based on evidence you see and hear in the courtroom. You must not consider information that comes from anywhere else. This means that until you deliver your verdict, you must not read, watch, listen to, or receive any information, including opinions or commentary about the case, whether in newspapers, on television, the radio, internet, or other social media platforms. You also must not research any aspect of the case during the trial. This means research using cellular phones, computers, or other electronic devices to search the internet, as well as research with traditional sources like dictionaries, reference manuals, newspapers, or magazines. You must not investigate the case on your own or conduct any experiments concerning the case, including investigation or experiments using the internet, cell phones, computers, or other electronic devices. You must not visit the scene of an event at issue in this trial. It is necessary for you to view or visit the scene, then the court staff will take you there as a group under court supervision. You must not consider as evidence any personal knowledge that you may have of the scene. You must not share any information about the case by any means, including cell phone or social media. This means that even if you are not discussing the case with someone else, you must not post information about the case on social media, websites, or other manners. If you discover that a juror has violated these instructions, report it to the court officer. You may take notes during the trial if you wish, but of course you don't have to. If you do take notes, you should be careful that it does not distract you from paying attention to all the evidence. When you go to the jury room to decide your verdict, you may use your notes to help you remember what happened in the courtroom. If you take notes, do not let anyone except other jurors see them during deliberations. And of course, the court officer, if we had to come back, would secure the notes locked so no one else would be able to read them. Your notes will not be examined by anyone, and when your jury service concludes, your notes will be collected and destroyed. You can see that we have chosen a jury of 7. After you have heard all of the evidence and my instructions, we will draw lots to decide which of you will be dismissed to form a jury of 6. Possible penalties should not influence your decision. If you find the defendant guilty, it is the duty of the judge to fix the penalty within the limits provided by law. And as I said, I may give you more instructions during the trial, and then after all the evidence has been presented, you will hear the closing arguments of the prosecution and the defense. And following those closing arguments, I will give you additional instructions about the rules of law that apply to this case. You should consider all of my instructions as a connected series. Taken all together, they are the law that you must follow. And after my final instructions, you will go to the jury room to decide on your verdict. The verdict must be unanimous. That means that every juror must agree on it, and it must reflect the individual decision of each juror. It is important that you keep an open mind and not make a decision about anything in the case until you go to the jury room to decide the case. You must not let bias or prejudice or public opinion influence your decision. Each of us may have biases or perceptions about other people based on stereotypes. We may be aware of some of our biases, though we do not express them. We may not be fully aware of some of our other biases. Take the time you need to test what might be automatic or instinctive judgments and to reflect carefully about the evidence. I caution you again to avoid reaching conclusions that may have been unintentionally influenced by stereotypes. You must reach your own conclusions about this case individually, but you should do so only after listening to and considering the opinions of the other jurors, who may have different backgrounds and perspectives from yours. All right, so that concludes, at least at this point, the instructions that you will need to begin to hear this evidence. So at this time, we're going to go to opening statements. So on behalf of the people of the state of Michigan, Ms. Mitch.
Hi, everyone. So, ladies and gentlemen, this is a very straightforward case. This is an operating while intoxicated case. We're going to hear from Trooper Hinton, with the trooper with the Michigan State Police. He is going to talk to you about a traffic stop that he made that turned into an arrest of Mr. Johnson for operating while intoxicated. He will take you through the field sobriety tests that he conducted with him that to him showed that Mr. Johnson was intoxicated. He will take you through the stop itself. And I will play you some video of these as well so that you were able to put Trooper Hinton's words into an actual visual on the screen. And we'll make sure that everyone can see the screen as well, that everyone. You will also hear from Mr. Paul Ham. Mr. Ham is an RN with McLaren Hospital. There was a blood draw that was done in this case to establish if there was alcohol in Mr. Johnson's blood. And Mr. Ham is really here to talk about what he does in regards to these blood draws, just to give you, kind of a visual of what happens. And we'll finally hear from Mr. Ryan Gifford. He is employed with the Michigan State Police Toxicology Lab. And he is going to take you through essentially what happens when a blood sample is collected from someone who is suspected of drunk driving, what his role is, what he does, and how he analyzes that blood for the presence or non-presence of alcohol. And what will happen is you will hear his testimony and you will also receive his report that was authored, which showed that Mr. Johnson, at the time the blood was taken, had a blood alcohol content level or a BAC level, as we like to abbreviate it to, of 0.112. And again, he will go ahead and take you through really the scientific version of all that because I am not a scientist, so he will be able to explain it much better than I can. Again, ladies and gentlemen, this is a very straightforward case. We are here because Mr. Johnson chose it. Mr. Johnson chose to drink, chose to get behind the wheel of a car, and he chose to drive that. He chose again to do this on a highway that being 8 Mile, that is open to the public, which was being accessed by people of the public. Something very important that's a little rare in this instance, and Judge Johnson did already reiterate it, is that this court is technically for the city of Southfield. That has been established. However, jurisdiction is correct if something happens within 1 mile of that jurisdiction. That means that Mr. Johnson, which in this case he was, on the Detroit side of 8 Mile, Southfield has that jurisdiction because it is within 1 mile of this jurisdiction itself. And Trooper Hinson will, of course, help you visualize at least. Got one side of 8 Mile, you've got a median, you could throw a rock to the other side. It's within that 1 mile range. Therefore, jurisdiction here is correct. Again, there is that instruction that was already read and you will, of course, be given it at the end as well. Now, given all of that, ladies and gentlemen, I am hopeful at the end of this trial that you will find Mr. Johnson guilty of intoxicated. And I will leave it as that so you can get into the evidence.
Thank you, Ms. Mitch. Mr. Johnson, would you like to make an opening statement now or wait? Okay, go ahead.
Heard. There's one side of Southfield, one side. Have you ever been anywhere, somebody told you somewhere you wasn't?
Something you.
Hey. So. I've been shot in the leg, so first thing was right since they don't know nothing about my. They don't know about me having diabetes, they don't know about me being shot. So a lot of stuff is gonna come up.
Your Honor, I don't make it a point of objecting during opening statements, but none of this information was given to
We don't have anything.
counsel or wasn't in the report or anything. It's just coming out now.
Okay, so what is it, Mr. Johnson? If she has an objection to your some of your comments. I know it's very rare, but sometimes if they have no information on what you're talking about, they might object to it because it's.
I object to her saying that I'm guilty.
No. That's what she has to prove. She's objecting to the fact that some factual information you're giving the juror, it's never been presented. You have to share information between both parties. And so she's objecting to that being presented because you have not ever discussed that or given any information.
Well,
so continue on. And I don't know, but I'm thinking the part about the
yeah.
right? That you probably want to not discuss because it
That can also spike my alcohol then.
okay. Well, if you got a witness that's going to testify, I guess we won't stop the witness and we'll see.
The witness that comes in, I will cross-examine them.
Okay, now you can do that.
Like I was saying, I will present that and I will also question them, and you'll see that alcohol doesn't will be changed by your value. Other than that, it's pretty much straightforward. The only thing they have is blood alcohol level. Challenge can test when it's time. Where I was pulled over at, y'all see in the video. So, and other thing. Oh, part of the statements that the officer wrote, I mean, in here, I would want him to read them. Like, that's it.
Okay. All right. Oh, she. All right, so Ms. Mitch, are you prepared to call your first witness?
I am, Your Honor, thank you. The people have called Trooper Cleo Henson with the Michigan State Police, and we'll go out in the hallway in just a minute.